Yeah. All right, great. Well, let's kick off then. So welcome to this webinar. Today we're having the Q&A session. And yeah, this is an opportunity for you to ask your questions. It enables us to yeah, interact with you and discuss questions that you have. We have received many questions in advance, and we're going to tackle those questions. But please feel free to answer your questions in the sorry, to ask your questions in the Q&A box. All right, let's just check that yeah, no, we look good.
We're
Um,
good, and attendees are now coming in, so we're good.
yeah, so I'm just okay, perfect. So the first question that we got in advance was, have many companies got dataset anonymization initiatives to get value from data and to avoid compliance challenges? So this is an interesting question. I'll actually pop it in the chat because it's quite a mouthful. But really, that's the question, and it's really quite interesting. There are a couple of things that relate to this, and in my experience, a lot of organizations do have data anonymization programs, and it's really a good thing to do because essentially, once you've anonymized data, then it's no longer personal information because it no longer identifies an individual, and that's what personal information is. So what we're trying to achieve is by de-identifying information or anonymizing it, you then are able to do all sorts of things with it, and you're not restricted by the principles for lawful processing. So then I wanted to show you here, let's show you, this is pop here, and this is the key definition to have a look at here. So it means to delete any information that identifies. So means to delete any information that identifies. That doesn't make sense, which is strange. I'll need to check that whether that wording is correct, but that doesn't seem to be right. So it means to delete any information that identifies, can be used or manipulated by a reasonably foreseeable method to identify the, oh, so it's delete any information that can be used. Okay, no, sorry, it does make sense. So the key being here is that if you're anonymizing data, it mustn't be possible to be re-identified. And so the question is there a reasonably foreseeable method that somebody could use to re-identify the information? And that's the key. So if you're going to anonymize, it must be proper anonymization. And yeah, it must really make sure that you can't re-identify somebody. I think the other interesting thing in this context is the concept of pets or privacy enhancing technologies. Yeah, I mean, that's a topic all on its own that we could talk about for a long time, but often it works on anonymization is built into the process. And you get things that are data platforms where people contribute data to a platform. And in that scenario, often the data is then anonymized, which allows people to use it, or it allows people to use it, but it's got privacy by design built into the platform. So the other closely related topic to this is encryption. And obviously, encryption's not anonymization or de-identification. It's still identified, it's still personal information. It's just encrypted so that nobody can access it. So it's more of a security technique. But often people ask as to whether, when they're archiving personal information, whether they can simply encrypt that information, um, uh, and whether that means that the principles no longer apply. And the principles do apply because it's still personal information. It's just being secured very securely. But obviously, the whole concepts of post-quantum cryptography and what's going to happen when we get to quantum computing is a very interesting debate as well, which is beyond today's webinar. All right, so the next question that we got is, okay.
Are we
So
at a point in SA where the concept of data altruism by data subjects can exist and thrive in the data-driven economy?
yeah, this is another great question and a tricky one. So data altruism is the idea that I have my data and I could keep it to myself and I could insist that nobody else uses my data. Or I could say, actually, I'm prepared to make my data available to various people, including researchers, who can use that data in order to try and solve some of society's big problems. And so it's data altruism. It's giving of yourself for the public benefit or something bigger. Now, uh, yeah, I mean, I think so. So this concept very much comes up in the EU Data Governance Act. That act's been around for a while now. I think it's 2002 that it was enacted. And the EU Data Governance Act is a fascinating act. And actually, there's some really interesting developments around this. The UK has just enacted their law, which is called the Data Act, or some people refer to that as the Data Use and Access Act, or DUAA as the acronym. I don't really like that acronym. I prefer the UK Data Act. So let me pop this in here for you. Yeah, so that's the UK Act. But so there's definitely a trend globally to enact data laws that are not about data protection. They're much broader than that. They're about who can use it, why we should use it, how society can benefit from using data. And it's really interesting to see how those laws are developing. But so back to the question. So data altruism is definitely something that's part of the EU Data Governance Act. But this really got me thinking. It's a great question. Is that in South Africa? Let's think of 1 to 10. How mature is South Africa from a data privacy perspective? In other words, is people's data privacy protected? And I would say we're at a 2 out of 10. I don't think it is at all. I think that lots of people are processing personal information however they want. So data altruism actually only works where you've got very protected personal data and it's kind of all locked away. And then you start saying, okay, well, hang on, it's all locked away. We can't achieve various important objectives unless people agree to make it available. So at the moment, I don't think the concept in South Africa is really significant because it's currently being used extensively anyway. But I can see that growing in future. And I do know that some organizations have shared, so this is not an organizational level, not at an individual level, data subject level, but some organizations have agreed to share a lot of data that they have for altruistic purposes. So yeah, it's an interesting one. All right, so the next question. So this is one that comes up a lot. We often get asked this question. So yeah, sorry. So I'm posting in the chat because I can't put it into the Q&A. So yeah, this is an interesting one. I think there are a couple of components to this. The one thing I wanted to do. So just to share my screen and come to this module here. So this is the lawful direct marketing module in the data protection program. And here we talk about opt-outs and control their preferences. And we give some examples here. It's very important that your opt-outs are very granular and that you enable people to really choose. And so these opt-outs should relate to not necessarily subsidiaries, but more products, and maybe products offered by different subsidiaries. Because what you don't want is for the responsible party, sorry, for the data subject to opt out of the whole group. You know, they get one communication which they don't like, and the data subject then says, okay, I'm opting out, and they opt out of everything. That's a disaster. You definitely don't want that. So you want, if wherever you've got to give the opt-outs, the data subject should land on the opt-out, and then that's where you want to be granular and almost encourage them. Because what you can also do is just have an opt-out which says, so you have different opt-out places, landing pages coming from different communications. So someone gets an email from one subsidiary, the opt-out goes to an opt-out relating to that subsidiary, not the whole group. And you actually don't give them an option of opting out of the whole group, only of one subsidiary. So I hope that makes sense. And then the other key thing here that's really important is that, and this applies to all marketing, you have to define who the responsible party or the controller is. In other words, whose customer is it? Who's providing the goods and services? Who is marketing to the customer? And you'll remember that the wording of a responsible party and a controller includes a few little words that make a big difference. And the words are alone or in conjunction with others. So a responsible party or controller can be one company, one subsidiary, or it can be a group of companies. And it can even be two unrelated companies. But it just shows how important it is to know who the controller or responsible party is. Because if it's the responsible party is the whole group and a data subject opts out, they are opting out then of the whole group. So we back to mapping activities, and it's really important to be able to accurately assign who the controller responsible party is to a particular activity. Okay, so hopefully we've covered that one. All right. The next question we got is, and this was actually an internal question that we received. Often, a lot of people in Microsins ask us questions. But last week, Wednesday, the regulator held a webinar, and it was really about the regulator's portal. It was about PIRE reports. It was called Ask the Regulator. So we decided to attend that webinar and to see if there was anything interesting for our members to save you the time. And there were a few interesting things that came out of it. So firstly, mainly private bodies were there. There were very few public bodies. Another interesting thing is that about a month ago, there were 8,000 bodies, private bodies, had submitted PIRE reports. And I checked yesterday, and it's now at about 55,000 private bodies have submitted PIRE reports. So people really are submitting them. A lot of people are submitting them. So they showed us that they have entered into a partnership with CIPC, the company's office, and they've done a number of work relating to the Biz portal. So you can now log into the Biz portal and access information regulator related information, or you can log into the e-services portal and access that same information. So that's quite interesting particularly if you've got a Biz portal login and you log in, you can see which companies you're associated with, and you can see their compliance status through that portal.
Yes, John, I actually saw it even shows whether you've submitted your PIRE report or you're an information officer at the bottom of your company details.
Yeah, perfect. So the regulators also really stepped up the transparency relating to POPIA and PIA compliance. In other words, they've really tried to say, we're going to broadcast this as to whether you're compliant or not to the public. So anyone who wants to look at it, you can look at it through the BIS portal, or you can look at it through the e-services portal and see what someone's compliance status is. The other key thing that came out of that webinar is that if you're submitting your PIA report, there are 9 questions that you have to give an answer to, and it's a numerical answer. So it's 0, 5, 40, whatever it might be. But a key thing is that there are 9 questions. If you answer 0 to question 1, all the rest are 0. So you almost don't need to engage with the other questions. You can just put 0. We are encouraging people to still engage with the other questions because they guide you on what you need to be looking out for the next reporting period and for what you should be doing should you receive requests for the next reporting period. Then another interesting thing is that they spoke about the personal privacy score that you can do in the portal. And I've done that, and it is quite interesting. They're basically saying it's like a short course in data privacy, and they're trying to help people get better at protecting, help data subjects get better at protecting their own personal information. So that was quite interesting to look at that. And then there were a number of technical questions that people asked, and one of the keys that really unlocked a lot of the answers is that the system works on ID numbers. So access to organizations, it's all related to personal ID numbers. And so if you make a mistake with an ID number, like you're putting in an information officer or an admin officer and you get the ID number wrong, that causes a whole lot of issues from an accessibility perspective. So that's a key thing to check. And I have seen that being a problem in various circumstances. And then the last thing that was interesting is that the regulator plans they said next month, they're going to go live with their complaints functionality. So people will be able to lay complaints through the e-services portal, and the regulator has been developing a complaints management system to enable them to do it, which I assume is now ready to go live. So that's an interesting development, and I think that it's going to translate into more complaints. I could see the regulator having it on their website saying complain to the regulator, and it clicks through to the portal, and so that happens in a much more streamlined way, and they'll be able to manage those complaints. And it'll be interesting to see what they do, because the regulator has been really big on transparency, and it relating and resulting in accountability, which I think is good because, they're responsible for the Promotion of Access to Information Act. So it would be quite ironic if they weren't being transparent about what they were doing. So, yeah, I mean, it could even be that you could anyone could log into the e-services portal, find an organization, have a look at it, and see how many complaints have been laid against that organization. That could be possible. So obviously we'll watch that very carefully, and we'll let you know what comes up in that regard. All right, so then, Rafi, we've got a question that came in, and I think you're the best person to answer it.
Yes, the question is, what is the difference between a POPIA policy and a manual? So, and a POPIA manual. So, first of all, there's no such thing as a POPIA manual. POPIA doesn't require you to have a manual, but PIA does. But before you can understand that, let's get into the definition. So, a POPIA policy would be what we call a privacy policy. And it is a document that explains how you process personal information within your organization, how you collect it, how you use it. And it must tell the data subjects this list of information and be in a clear and accessible manner. That's why it's imperative that you put your privacy policy on your website. So any user and data subject that you engage with or engages with you understands how you use, share, collect, and process personal information. Now, a PIA manual, as I said, is governed by the Promotion of Access to Information Act, and that is mandatory for all private bodies and public bodies. And it is a guide that details how you hold any record. So it doesn't matter whether it's personal information or not. It's how you um, the records that you hold and how you process these records, and well, not process these records because that's privacy policy, but how you process data subjects requesting for access to their information. But as a background, when POPIA started, POPIA commenced, it amended PIA to add certain privacy-related provisions. For example, the categories of data subjects and the purposes for which you process information. We all know that POPIA and PIA are somewhat interlinked because, especially when we're dealing with records and information. So most people would think that it is called a POPIA manual because POPIA was what drove the need for transparency, but also there needs to be a transparency of access to information. So that is the difference between a privacy policy and a PIA manual. What's the piece?
Yeah, thanks, Rafua. Yeah, I mean, I think the regulator created some confusion by saying that certain privacy-related things needed to be in a PIA manual. That's where the confusion started. But we're firmly of the view there's a PIA manual and there's a privacy policy. That's the right way to do it because that's what people expect to find privacy-related issues in a privacy policy. They don't expect to find it in a POPIA manual or a POPIA policy. That's not the place to have it. It should be in a privacy policy or a privacy statement. But a privacy policy seems to be the term that has dominated.
And so furthermore, we need to also distinguish between, which is the next question, what is the difference between a PIA report and a PIA manual? So as I said before, a PIA manual is the document detailing the records that you hold and the process for requesting and the contact details of the information officer. Whereas the PIA report, as John has talked about submitting a PIA report, is basically an annual return to the information regulator detailing how many requests were received, answering those 9 questions, what was granted, what was refused, on what ground, and turnaround times and the fees charged. And with the PIA manual, you would update it regularly, but with the PIA report, you're mandated to submit it at a certain time by the 30th of June every year.
Yeah, I mean, there are lots of people asking this question. And I think the deadline for submitting your annual PIA report is now at the end of June. So it's a hot topic and it's coming up a lot. But what a lot of people have realized is that they're submitting their report and then and you look at the portal and you say, well, but have you got a manual and have you submitted your manual? And then they go, ooh, okay, no, I haven't done that. So let me show you this, which I think is worth having a look at. So this is obviously logging into the regulator portal. And so anyone coming in here can search for any organization. I mean, well, who should we search for as an example?
That is, especially that's guaranteed, that is
Let's go for Nedbank. I don't know.
yes, the bank. Yes, definitely.
So there's Nedbank, and we can look at the organization. And so bearing in mind, anyone can create a profile on e-services and then search for any organization. So this is a public record, anyone can see it. So the organization details are there, the information officer is there, deputy information officer is there, and then PIA annual reporting. So they have submitted. They submitted yesterday, actually. And there is their submission for the last year, which is quite interesting. We've got 62 requests, etc., etc. So that's good. So then let's go to the next window is the Pire manual. Now they haven't submitted or uploaded the manual to the portal. So like, well, why not? You've done your report, but why not the manual? And so the regulator has asked that the manual be in the portal, and you should be putting your manual in the portal. You should also be adding how and what records are automatically made available. And then you should also be doing these assessments. So I think that's a key thing that people are starting to realize is that, yes, okay, well, I've done my PIRE report, but what about the other stuff? And that's why they're asking the difference and trying to figure out what to do about it.
John, do you think it would be a red flag per se if you submit your PIRE report, but you don't have a PIRE manual?
Yeah, absolutely.
Um,
The regulator or anyone can go and have a look and say, okay, well, yeah, you've submitted your PIRE report, but where's your manual? Absolutely. And I think the regulator, that's exactly that they created the e-services portal, and those are the things that go against any organization. The reason they're there is they want you to do it. Yeah.
okay, and now the next question is, what is the difference between an admin officer and an outsourced IO?
Um, so I would largely say they're the same thing. So we've been talking about this for a while, and so let me try and recap it but keep it short, is that you can't outsource the role of the information officer to somebody else, to an external party, but you can outsource the responsibilities. So in other words, what an information officer has to do, that can be outsourced to somebody else. So if you outsource that to somebody else, that person does not become a deputy information officer for your organization and is then not in the portal as a deputy information officer. But obviously, if you're asking somebody outside of your organization to fulfill responsibilities and to upload a manual, do the reporting, etc., they need to get access to the portal to your organization to be able to do that. And that's where an admin assistant comes in, or an admin officer is what they're called officially in the portal. And so you can add an admin officer to your profile, and that person then is able to do things on your behalf in the portal. And so they're not an outsourced IO, they're somebody performing some of the responsibilities of an IO that you've outsourced to them.
But John, what are some of those responsibilities? Because you could have access to the portal and deal with those, for instance, a security compromise, updating a PIRE manual, submitting a PIRE report. But what about a response to the regulator, for instance, in a pre-investigation notice?
Hmm. Yeah, good question. So last week we did a webinar. Was it last week? I think it was last week. Sure, time flies, I get confused. But last week we did the webinar on fulfilling the responsibilities of an information officer. And in it, it was a webinar for members. And if you haven't seen it, you will have access to it. And essentially, we've identified 21 core responsibilities for information officers that for us is the core or the minimum of what they need to be doing because they're required really by law to do those 21 things. And so submitting a PIRE report is one of them. Having a manual is part of one of them. And but really those are the 21 things that you could outsource to somebody or are things that an information officer should be doing.
Thank you. And so the next question is, what action can I take if a country does not have a data protection authority but its law requires, for instance, requires a requirement like registration. So a background, the person who asked this is in another country, and they wanted to know what happens if, for instance, prime example would be Lesotho, that has a data protection act, but they don't have a data protection commission established or is not in operation as yet. What steps does one? And so in practice, you should you should consider the legislation as dormant but not dead. What this means is you would fulfill the requirements in the act as if they were an authority, and you would create a sort of a register and a documented map, all the same way that you would submitting to the Data Protection Commission or authority. You would collate all that evidence and show that you're able, that you have fulfilled the requirements of the Act. Until such a time that the commission is established, you could provide that information to the commission or the Data Protection Authority. Alternatively, you could also engage with the Ministry of the act in which the data protection is governing. So, for example, the Data Protection Act in Lesotho, the Ministry of Telecommunications is overheads the Data Protection Act and laws and the commission that is yet to be established. You could also engage with them and provide this information so that they also have on record that you're doing your best to comply with the data protection laws of that specific country until such a time that the commission or authority is established. And most importantly, it's important to monitor the Gazette for any updates on, timelines of when commissions are established or deadlines for registrations as a data controller or as a data processor, or in our country, or in South Africa, as an operator or a responsible party. A lot happens and time flies, and these gazettes come out quite often. So it's important to just flag that, follow the right authorities on, for instance, LinkedIn and other data protection sources so that you are aware of when a registration timeline is due.
Great, thanks, Raviwa. Yeah, so I think the next question that we got is, how do we submit a PIA report? And this is obviously relevant because the deadline is the end of I'm going to show you really quickly now, just as a recap. So you're in the regulator portal, you're on your page, you've got your organizations, which you can have a look at. But the best place to go to here is there. You can submit your PIA annual report there, or you can view all services. If you view all services, you obviously have to have registered the organization and the information officer, and it has to be connected to your profile. But then essentially you go into the PIA reporting component. You'll see the period is 1 April to 31 March 2025. And then you add a new submission. You then would choose a company that hasn't done it. And you then get to this form over here. And you've got these 9 questions. You've got to give a numerical response. And so if that's 0, then the rest are 0. But like what we saw there with Nedbank, if you've received requests, then you obviously these numbers are going to be different. And you submit the report. And that's all there is to it. It literally can take you a few minutes. A lot of people, I think, have thought, oh, no, this is like it's a whole report. I've got to write a whole report. and send it to the regulator. And it's not, it's just submitting statistics and can generally be done very easily. All right. Yeah, so the other question that we've been getting a lot of from a lot of people is, what role does a data protection officer or an information officer play for AI governance, risk, and compliance? So, we deal with a lot of information officers, and I think, and I know a lot of information officers and DPOs are thinking to themselves, okay, well, am I going to be the one responsible for AI governance? And should I? And can I? And so it's a really good question. And what we did is we tackled this issue in a module in the Trustworthy AI program in quite a lot of detail about, yeah, thanks, Rafi, we're about establishing the right team for AI governance. And I think a key point that came out of that is that you have an AI officer or a chief AI officer, and that person is really on the business side. They're on the innovation side. They're on the how do we leverage AI to make money. That person is really focused on the innovation. Then you have somebody that's called, the name differs, but there's a common theme of somebody called an AI governance officer or AI governance lead or AI GRC lead. Now, that person is much more about the brakes in the car and saying, hang on, we've got to do this safely, reliably. Do we comply with the law? Is it lawful? That's more their role. And I think it's really difficult for the same person to play both of those roles because you don't have checks and balances in place. And so ideally, you want to separate them. In other words, there's the lead in an organization to leverage AI, and there's a lead in the organization to govern it and to do it responsibly. And I think that's the best structure. And so when we're talking about an AI governance officer, that's where a DPO and an IO can play a significant role, possibly the whole role. So it might be that you're an information officer and it's currently 50% of your time. You could spend the other 50% focusing not just on data protection, but on AI governance. Yeah, so hopefully that helps. All right, so the next question, and this one's a great question, is who must comply with PIA? For example, must a trust comply? Now, so this is the question. So it's pretty clear who must comply with POPIA, but the question is who's got to comply with PIA? Now, we've written about this as you would expect. So it's essentially public and private bodies, and public bodies are quite easy. Private bodies are the interesting one. And basically, this is what the section 1 of PIA says, that it's any private body. So it's a natural person who carries on a business, a partnership which carries on that business, a former or existing juristic person or political party. Now, the two interesting things that have come up and been asked is the one is, must a trust comply? And a trust is not a juristic person, therefore it doesn't fall into this list, therefore they don't need to comply. For me, that's the answer to that one. And then the other key question is, which juristic persons? So the fight that the regulator is currently having with Meta is that they're saying to Meta, well, you're a juristic person, you need to comply with PIA. And Meta's saying, no, I don't need to comply with South African law. Why do I need to comply with that? So it's really a constitutional law question, and I don't know the answer at the moment, but I'm going to try and work out what it is. But just looking at the list of who's here today, I think many of you, it's pretty clear cut whether or not you need to comply. Although some of you might have holding companies in other countries. And so the question would be, well, yes, the South African subsidiary needs to comply, but what about the global companies? Interesting question, actually, because it might mean that the South African, say you're in a group of companies that's a multinational, the South African entity might need a PIA manual, but none of the other entities within the group. Yeah. All right, and then the other question, I've sort of touched on it already, is that yeah, people have been asking about the UK Data Act, or the UK Data and Use, sorry, Data brackets Use and Access
Use
Act.
and access.
Yeah, I mean, I really don't like I posted it earlier. What was it's the DUAA as an acronym. That doesn't roll off the tongue.
Doesn't do a.
I prefer the UK Data Act, and it's a fascinating act. So one of the best things to show you here is this. I've had quite a look around, and I think this is worth looking at. The ICO always produces good content, and this at a glance summary I thought was really good. So it's about digital information matters. So it's about all data. So it's not just about data protection or personal data. It's all data. And it basically changes data protection laws to promote innovation and economic growth. So the UK for a while now, and it's part of the why Brexit happened, is that they are saying Europe over-regulates. And as a result, the UK are now watering down the GDPR and essentially removing some of the obstacles. So that's really interesting. And then, yeah, it's interesting that it's saying it's actually an opportunity to do things differently rather than needing to make specific changes. So they're purposely trying to say, look, this isn't another compliance requirement. It's not like going to kick off a whole new compliance project. It's more relaxing things so that you've got more freedom to do things. So that's, to do things differently is you've got more freedom, there's less restriction. And then the changes are phased in between June this year and June next year. And that timeline correlates with the process for the EU to decide whether the UK has adequate data protection laws in place. And obviously, this is a big issue. The UK want to be found to be adequate because otherwise there won't be cross-border transfers. But at the same time, they're trying to promote innovation, cut red tape, and reduce regulation. So the EU might turn around and say, sorry, UK, I don't believe that you have adequate laws because you've introduced this Data Act that waters down the GDPR to such an extent. Remember the European Data Protection Board, they're also investigating how they can exempt certain people and remove some of the restrictions from the GDPR. So it's definitely a global trend away from regulation towards innovation. We've spoken about that many times. So I mean, yeah, I mean, so I'm really interested from you. Would you be interested in more content on the UK Data Act? Would you be interested in more content on the UK Data Governance Act? Maybe you can pop in the chat there whether those are things that you are interested in and would like to know more about. We can, if that's the case, we can set up webinars just on those topics if that's interesting for you.
In fact, John, we posted about it last year when it was still a bill. So it would be interesting to see the changes, and we'll make those changes accordingly onto our post.
Okay, great. And then, Rafiwa, we've got some good events coming up next month, haven't we?
Yes, very exciting. Very exciting. We're getting into the nitty-gritty. I'm super excited about July's webinars. On the 9th of July, we start with doing a regulator ready gap analysis, and it's open to members and to the public. And then we take a different turn and we go into cybersecurity compliance. And we've always had cybersecurity compliance program, but we wanted to bring it more to light because where data is, where AI is, um, cybersecurity is at the forefront. And it's important that we remind ourselves and recalibrate on cybersecurity compliance. So on the 15th of July, we will be starting with what we call a cybersecurity compliance series. The first part is exploring why cybersecurity is a mission. And then the second one on the 22nd of July is knowing the regulations that require cybersecurity. And then on the 29th of July, we have, which is the final installment, which will be applying the art and science of cybersecurity. This will be hosted by our amazing David Late, and we really hope that you can join us in the cybersecurity space. And of course, as always, every 3 months, we have our Sustaining Your Efforts compliance efforts webinar, and that is on the 23rd of July. I'll pop all of these in the chat.
Great, thanks, Rafiwa. Yeah, so I think so the one that we're doing on the 9th of July on a regulatory gap analysis, that's a really interesting topic, and it revolves around the self-assessments in the regulator's portal and how you would go about doing a gap analysis against those so that you're able to respond to those self-assessments in the portal. It's yeah, I think it's we've been working hard on that content, and I think will be really good. And then the cybersecurity compliance program, yeah, what we've found there is that obviously there are many cybersecurity experts, and cybersecurity is a really important thing that people have been doing for a long time. But where there's a big gap is that people are not aware of the laws or the regulations relating to cybersecurity. And so that's what this program is seeking to achieve, is really to help information officers, legal professionals to get a better idea of cybersecurity regulation and to help cybersecurity professionals get a better idea of the regulation. Because you have to understand the regulatory framework within which you operate in order to get cybersecurity right. So that's why we're tackling that. All right, I think yeah, I mean, as always, please let us know what you would like as members. What content would you like us to cover? Are there any webinars that you would like us to do? We very much are driven by the members and what you want. So please let us know if there's any topics that you're interested in doing. You can pop it into the chat now, or you're also welcome to email me at john@michelsons.com with requests on topics that you'd like us to cover. All right, I think that's it, unless there aren't, if there are any other questions from you. No.
Okay, no question.
So let's quickly just run the feedback poll and see whether, yeah, what you thought of today's session. Always welcome feedback. All right, great. Thanks very much. All right, so I think should we leave it there? Thanks very much, Rafiwa. Thanks for joining me. And
Thank you, John.
thanks to all of you for joining, and I hope you enjoy the rest of your week.